Good afternoon, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. We're going to give it a few minutes, let some people hop on here, because I've got some important things to talk about to everybody today in regards to using their words against them. And a lot of it stems from their very words, of course, obviously using them against them. And so we're going to go over a couple sections in the United States Code, as well as Article 2, Section 2 of the Constitution real quick, as well as some other things in regards to the heading of the post here or video is notification of legal responsibility, which is the first essential element of the due process of law. And if we comprehend this correctly and realize how these people are interacting with us, we can take on that responsibility of that notice, and we can do so competently. And I'm hopefully I'm going to be able to show you here through this first part anyway, one of the very important things about all of these courts and the officers of those courts and how they operate in trust. So the first thing I want to talk about, of course, is when we think about using their words against them and the notice of legal responsibility being the first essential due process of law, we think about a 1966 case, Miranda versus Arizona, wherein they came up with this Miranda rights thing. And it starts out, of course, you have the right to remain silent. Okay. You have the right that anything you say can and will be used against you in a court of law. Now that one I have a problem with. And that's the one we're going to talk about. But then it goes on to say, you have the right to an attorney. I also have a problem with that. If you cannot afford an attorney, one will be appointed for you. I also have a problem with that. First of all, let's talk about number 4. If you cannot afford an attorney, one will be appointed for you. Now, the Fifth Amendment says I have a right to counsel. So let's talk about the variance of law. That's where we're going to talk about the Constitution. Number 3. Because, well, first, let's expand on number 4. First of all, if you cannot afford an attorney, one will be appointed to you. I was told I am afforded counsel. Well, I also believe that I am afforded counsel prior to that Fifth Amendment. I'm told to seek counsel in His Word. So no matter how you want to define your attorney BS, I'm going to rebut it because, in fact, the Constitution prior to this Miranda rights used a different term called counsel. If you want to say that attorney is my counsel, I'll beg to differ because American jurisprudence says otherwise. Inconsistency, again, variance of law. Number 3, you have the right to an attorney. Again, like I said in number 4, an attorney is not counsel. An attorney is one who turns over things. I'm not here to turn anything over. I'm here to prove. I'm not here to destroy the law. I'm here to fulfill the law. I'm not here to turn anything over or destroy it. I'm here to keep it in the capable hands of where it's supposed to be, and that is in the heart, where in the Word, in the beginning was the Word, and the Word was with God, and the Word was God, and the Word was God is what makes law. I make law with what's right here. Anyway, number 2, yeah, you do have the right to remain silent, but again, we're going to skip over to number 1 because I want to clarify number 1 first. You have the right to remain silent, but I'm told that I'm supposed to sing in the glory of His Word. I'm told that I am sanctified and ordained as a prophet unto the nations, and that is my duty, to wear the boots of His gospel as I sojourn across the lands, with the belt of truth cinching up the breastplate of righteousness that I wear. because the sword that I bear is the word, and the shield that protects me is the faith of that word, and the helmet on my head is the helmet of salvation. I don't need to be salvaged. I have salvation merely by self-recognition. So though you may have the right to remain silent, I suggest you learn the word and how to express it at all times. So number two, the one that I have a problem with, says anything you say can and will be used against you in a court of law. My problem with this is that if I am speaking the truth, then how can it possibly be used against me in a court of law? This is babble. This is very befitting of the officer that wants to pull you over and alongside the road. When he wants to ask for capacity, from now on, I will assert that notice of liability, that notice of responsibility. Notice of legal responsibility is the first essential due process of law. Do you recognize that? Oh yeah, but I'm not here in that case. Well, I'm giving you your warning that you have the right to remain silent, and that anything you say can and will be used against you in a court of law. Now, you do have the right to an attorney. I will even accept your counsel. Now, if you can't afford that counsel, if you can't find that counsel, I'm sure an attorney will be appointed for you. So let's talk about this first. Notice of responsibility, notice of legal responsibility. Notice of legal responsibility is the first essential of due process of law. This you can find in U.S. versus Tweel. If the county recorder or any county, state, or federal clerk, agent, officer, including any courts, gives you any excuse about accepting or filing your documents, notify, inform, educate, warn them according to the following. So when we're talking about that officer alongside the road, it did say officer. If the county recorder or any county, state, federal clerk, federal agent, federal officer, including any courts, gives you any excuse about accepting or filing your documents. So, let's go to U.S. Code Chapter 1, Rules of Construction. This is the very first code, very first section. Okay? And in this section it has subsection 1, 2, 3, 4, 5, 6, 7, 8. And these are all definitions. Very important definitions, as we see. It says words denoting number, gender, and so forth. So forth, very peculiar. But then we see the other definitions, county as including parish, and so forth. Vessel as including all means of water transportation. Vehicle, meaning as including all means of land transportation. Company or association as including successors or assigns. Notice they didn't quote those because those can have different meanings. Notice they didn't quote these because they can have different meanings. Note they didn't quote water transportation. That can have different meaning. And all we need to do is limit their meanings. This one here is 6 limitation of term products of American fisheries. A peculiar one, but when we look at it, it has a very interesting statement in here. I suggest everybody look at that. If you have any questions, ask me for clarification. I will help clarify that. But then it goes on to one of our more important ones, marriage and spouse. And of course, the ones we're always interested, person, human being, child, and individual, as including born alive infant. Okay? But guess what? We don't notice anything about officer there, do we? Let's go to this first one, where it says words denoting number, gender, and what I said here, notice so forth. That's a peculiar portion, and so forth. What the hell is so forth? Can they define so forth? They're going to here. Person, insane person, person, individuals, officer. Uh-oh. Officer includes any person authorized by law to perform. That's an obligatory position. It's an obligatory position. The duties of the office. What office? It's not capitalized. It's not in quotations. It's just a general sense of the office. Words denoting number, gender, and so forth. And so, as we go forth, again, we're still in 1 U.S. Code Title 1, Rules of Construction, Section 1. Acts and resolutions, formalities of enactment, repeals, sealing of instruments. Doesn't say anything about documents, but it does speak of instruments. So let's look at this. Enacting clause, section 101. It's not the first section, it's 101. The enacting clause of all acts of Congress shall be in the following form. Being enacted by the Senate and House of Representatives of the United States of America in Congress assembled. Okay, simple. The resolving clause of all joint resolutions shall be in the following form. Resolved by the Senate and House of Representatives of the United States of States of America in Congress assembled. Okay, again, the only difference is this is being enacted has been changed to resolved. Okay, first they have to enact it, or first they have to resolve it, and then they have to enact it. Okay? Enacting or resolving words after first section. Enacting or resolving words after first section. No enacting or resolving words shall be used in any section of an act or resolution of Congress except in the first in any section of an act or resolution of Congress except in the first. Are they referring to the first section or the first act? Here, no enacting or resolving words shall be used in any section except in the first section. That's not section 1. That's section 101. Chapter 1, section 1, the first section, words denoting number, gender, and so forth. (126.1619). (126.1619), 21st Century Language Act. Bills and statutes. An act to strike the word lunatic from federal law and for other purposes. Full title. House Resolution. Uh-oh, it's never been enacted. It's only been resolved. How about that? It's never gone to Senate. It's only been resolved in the House. Complete textual section of the legislative history printed at the bottom of the law. Search field operator example is MODS, legislative history, natural resources. Congressional Record Volume 158, 2012, May 23, considered and passed in Senate. December 5th, considered and passed in House. But I don't see where it's been enacted. Been resolved between the House and the Senate, but I don't see enactment. An act to strike the word. So even though these others, I don't know, we'll have to check that out. But what I'm pointing out here is I don't see any actual resolution by both House and Senate and enactment in the first section. So, supposedly, according to Chapter 2, Acts and Resolutions, where they finally start talking about Acts and Resolutions, not in the first section. So how can anything actually be enacted or resolved if it isn't enacted or resolved in the first section? Wherein they only define the terms. It isn't enacted against a private man until the private man accepts these terms or these definitions. When you learn how to rebut these definitions and know that you are competent and not insane, because you are not the person, you are not the individual, you are not an officer, you don't subscribe to giving signatures, because you don't swear to an oath of another man in writing. You have, in beginning was the Word, and the Word was with God, and the Word was God, and God is the one that gave you oath, and you accepted His offer of His oath. You accept your neighbor, both plural and singular, both female and masculine, present and past and future. This is not a question. But remember, He is a respecter of no person, so I know the difference. I am not the person. I am competent as a child of God, as a lamb of God, to speak His word. and denote other things as set forth, which haven't been set forth in the first section here. Period. We're going to skip over to 5 U.S. Code, Federal Advisory Committee Ethics in Government Act of 1978. Financial disclosure requirements of federal personnel. Each report filed pursuant to Section 101D and E shall include full and complete statement with respect to the following: the source. The source. Type and amount or value of income. These people are getting paid to do this. And so they will always refer to the source as a commercial source. Period. Their commercial source extends from Section 2 of Article 1 of Article 2 of the Constitution, relating to the executive branch, how they execute things. The only way they can execute things is through their emoluments, is by getting paid for it. They will not do this for charity. And under Article 2 of the executive branch, the executive power under Section 1 shall be vested in a President of the United States of America. Section 2 says the President shall be Commander-in-Chief of the Army and Navy of the United States and of the militia of the several states when called into actual service of the United States. He may require the opinion in writing of the principal officer in each of the executive departments That's not capitalized. But the officer is. Again, denoting that even though the executive department isn't actually noticed as a commercial entity, the officer and the department is. So whether they capitalize executive here or not makes no difference, because they've already commercialized the officer and they've already commercialized departments. Upon any subject, again, saying that they are subject to the commercial entities relating to the duties of performance. Duties are obligations of performance of their respective offices. And he shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. In cases of impeachment, he cannot grant reprieves and pardons because impeachment is on basis of the people. The people impeach these people through accusations and prosecutions of what's known as high crimes. These are done in admiralty courts, not U.S. Code 1 words denoting number, gender, and so forth courts of commercial venues that have no enacting or resolution clauses because they have yet to be enacted or resolved unless you sign denoting the words, numbers, and gender, and so forth, your own self. So again, when that officer pulls over alongside the road and asks you for a license, give him notice of legal responsibility in his capacity being paid emoluments. He is subject to the terms and conditions wherein words denoting number, gender, and so forth are yet to be discovered. This is important because the next element of legal responsibility is discovery. We're not going to go into that today, but that's the basics of the order of things. So, back to this. Warn them to the according. When he pulls over and you read him the Miranda rights, and a refusal to record my documents is a crime under Title 18 U.S. Code 2071 and is punishable by fines and imprisonment. Should you refuse to record my documents because any attorney, district attorney, or anyone from the lawyering craft told you not to file any such documents, you are still responsible, as I do not accept any third-party interveners. An attorney, district attorney, or anyone from the lawyering craft are all third-party and not licensed to make legal determinations in any matter because they do not represent me or you, the county clerk, or anyone else. Furthermore, an officer may be held liable in damages to any person injured in consequence of a breach or any of the duties connected with his office. The liability for nonfeasance, misfeasance, or for malfeasance in office is in his individual, not his official capacity. And you can refer to 70 American Jurisprudence 2nd, Section 50, Part 7, Civil Liability. This is reiterated. Biffle versus Morton Rubber Industries, Texas, 1990. An instrument is deemed in law filed at the time it is delivered to the clerk, regardless of whether the instrument is file marked. Comprehend three main important parts here, people. Notice of legal responsibility was first given to the officer. The officer has a right to an attorney, and that's exactly what he's going to use. He's going to use an attorney by turning that document over to an attorney called the district attorney. That district attorney is then going to file his document with the clerk. In the notice of liability to the officer, he is going to retain counsel, and they are going to file with the clerk. The officer is both operating as a trustee in his public capacity as an officer of the court. He is issuing an instrument to the attorney. He is therefore, in that act, a grantee, granting property that he signed and turned over to the attorney in a trustee position. Again, another officer of the state, who then turns it over to the clerk, again in trustee position, granting him a commercial transfer. Now, the officer is operating as trustee and grantee while being a benefit of emoluments. the prosecutor is operating as trustee and grantee to the clerk under emoluments. The clerk of courts is the chief financial officer and is a trustee under the state, who is also a trustee of a foreign trade zone wherein the commercial aspect resides. And this is why they use the court registry investment system. At the time the attorney has it, he has the ability to determine whether it's law or commerce. The officer is incompetent to determine whether it is law or commerce, and can't sit on that stand to determine otherwise when you rebut that first code. It's never been enacted. It's never been actually enacted by anybody. It's been resolved by the House and the resolution and the people that sat in them seats at that time according to their opinions, but it's never been enacted as law. Not once. And therefore can only be administered under Title V of the United States Code administratively in their office of the courts, namely the Government Publications Office, Government Accountability Office, and the U.S. Department of State. You'll notice I've mentioned three people: the officer, the DA, and the clerk. They are all operating under that public trust, all operating under all three capacities, assuming the private man is part of that public trust and dragging his ass into the court. It's your responsibility to give them the notice of their legal responsibility by pointing out that they are all three operating in all three capacities and how you recognize that. Now, the clerk of courts, like I said, has been assigned by the Secretary of State as a trustee of that district, the county district, in regards to the state's district, which is in regards to the U.S. district. So no matter whether that officer is a county officer, a state officer, or a municipal officer, he is operating in all three capacities at different times, handing over an instrument that he signed himself. Incompetent to do so unless he can prove his own commercial capacity and legal liability in doing so. And he can't do so unless he recognizes his legal liability. So when you read him his Miranda rights upon asking you for your driver's license, if he doesn't recognize his legal liabilities at that point, he is screwed. He is screwed if you can point out that he acted in a beneficial capacity under private emoluments, getting paid to do so without recognizing that contract and his obligations in it. His obligation isn't to stop the private man. His obligation is according to the way the statute, codes, rules, and regulations are all enacted. Not the way they're written. The way they're enacted. Again, actions speak louder than words. Got anybody that signs on the enactment on those? I don't see it. I see this officer saying that it has been enacted, but he can't prove so. All the way at the top level. He hasn't enacted anything. He, in fact, has made records and reports. False records and reports. I've got an interesting friend, and I'm sure there's many of them out there, that recognize this and can assert that they are actually acting in their private capacity. And if that officer wants to enact or interact with him, he cannot do so while he's getting paid and the private man is not. So unless he can prove that himself and you are both getting paid at the same time, he can't prove that anything is enacted. Period. He can't prove that there's a contract between you and him that he can prove his contract is actually enacted properly in order to stop you alongside the road for no reason. He can't. And once you recognize this, you'll see things. So as we see in Article 2, Section 2, the presidency proves that everything is done under martial law. In his enacting his corporate contract on the roadside by getting out of his vehicle and then purporting maritime transactions on the land by proclaiming, I am a vessel, is all wrong. So when we go back to 1 USC and we look at the third, fourth section, where it talks about vessel as including all means of water transportation and vehicle as including all means of land transportation, can he define land transportation without vehicle? No. He can't even define vehicle. He can't define vessel. So how can he define water transportation as opposed to land transportation when he can't even discern the difference between a vessel and a vehicle? Particularly under common usage, let alone under any supposed House or Senate resolution or House-Senate joint resolution. There's never been an enactment. So his own acts have to prove from his own definitions. Because even Congress hasn't defined it. Uh-oh. You better get some dictionaries out quick, because I can tell you the vessel. I can tell you the vehicle. Yeah? I am the vessel. I am the vehicle of his word. You dispute that? You say I'm a vessel carrying passengers? Where are the passengers? You say I'm driving a vehicle? Well, I'm the only one in it, so I have to be able to assert my right of use. Do I not have that right of use? Well, yeah. Do I have the right to determine the use then? Or can I only assert the right of use according to public use? Can I not assert my private use? Well, yeah, everybody's got a right of private use. Well, my private use doesn't have any passengers. It doesn't have any goods. It doesn't have any bills of lading. How are you professing that I'm driving them? You can't. So think about this stuff. They are making false reports and records. It is a crime against justice. Let's see. This is Revised Statutes of the United States. First session, 43rd Congress, 1873-1874. This is an old one. It still stands on and for the record. Every person who willfully destroys or attempts to destroy, or with intent to steal or destroy, takes and carries away any record, paper, or proceeding of a court of justice, filed or deposited with any clerk or officer of such court, or any paper or document or record filed or deposited in any public office or with any judicial or public officer shall, with reference to the value of the record, paper, document, or proceeding so taken, pay a fine of not more than $2,000 or suffer imprisonment at hard labor not more than 3 years or both. Without reference to the value of the record. Without reference to the value of the record. My legal responsibility of notice, or my responsibility of legal notice, is that your value of the commercial system Federal Reserve notes has zero intrinsic value according to HJR 192. House Joint Resolution. And I am enacting that now. Your citation has zero value. None. In fact, as a notice of legal responsibility, I have to warn you. You have the right to remain silent. Anything you say can and will be used against you in a court of law, and that court of law is a law of contract. And I will formalize this contract. I will do so without an attorney, because I can afford to do so without an attorney. Section 5407. This is Title 18, Crimes Against Justice. That was Section 5403, Destroying Public Records. This is Section 5407 of the same thing, Conspiracy to Defeat Enforcement of the Laws. If two or more persons in any state or territory conspire for the purpose of impeding, hindering, obstructing, or defeating in any manner the due course of justice in any state or territory with intent to deny to any citizen the equal protection of the laws, or to injure him or his property for lawfully enforcing or attempting to enforce the right of any person or class of persons to the equal protection of the laws, each of such persons shall be punished by a fine of not less than $500 nor more than $5,000, or by imprisonment with or without hard labor, not less than 6 months nor more than 6 years, or by both such fine and imprisonment. The next one, 5408, destroying record by officer in charge. And each one of these people is responsible for all three of these in each event. Because again, like I said, the officer in his benefit of emolument is acting as trustee. Unlawful conversion. The prosecuting attorney, the DA, also under emoluments, being paid as a beneficiary of the public trust, is acting as a public trustee. Not recognizing their commercial capacity and trying to enforce a supposed law against a private man by dragging his ass into a public forum, again proving they are operating in a public capacity while receiving emoluments. The clerk and the prosecuting attorney, both under that benefit of public capacity and being paid under that public trust, are converting the public trust funds from the original source by getting that information and converting it for that specific commercial intent of contracting under those words denoting numbers, gender, and so forth, without having the proper enactment clause to do so. They are in fact searching for information to enact it. And by your joinder of signature, without qualifying it, it enacts those words, numbers, or words denoting number, gender, and so forth. You do so on every check that you sign where you change the numbers or write down both the numbers and the English written language of numerical or denoting the numbers in the written English language. And then you denote them again in the numerical sequence. It's very important to comprehend that. You don't have to subject yourself to both forms and institute both forms. You can do everything by word. You don't even have to write it down. Period. Let's get on with the next one, 5408, destroying record by officer in charge. Every officer, again, we're talking, they're all in collusion because they're all officers of the court, proving bias. They're all beneficiaries of the public funds, again, proving bias. Again, they're all, as beneficiaries, getting paid emoluments through the public funds, are again acting in capacity of trustees and grantees somehow. They're changing those hats interchangeably, and the one on the side of the road is incompetent to do so. He's granting a contract and he's granting an offer. He's the one making the offer of the traffic citation and giving his signature saying that he's enacting it. He is the one in the interaction. He is the first person. He is in first person. He is first witness. He is witnessing it firsthand. Can he bring his second person in and talk about him in the third person like I can? I'll bet not. I'll bet he can't. I'll bet he gets all confused. I'll bet he thinks he's a female. I'll bet he thinks he's both man and woman and can't clarify the difference. I'll bet he thinks his next of kin is his daddy. Having the custody of any record. This is like I say when the officer pulls me over and says, "Can I have your ID?" I ain't got one. So he can't get custody of an ID from me because I can't give him one. Guess what? His next question is, "Well, what's your name?" He can't have custody of that either because I don't have that either. That's what the ID is all about. I don't have the ID, so I can't give it to you. According to the ID, it would be that, but I'm not even going to talk about that. I'll tell you what I see. I'll tell you how I observe things. And I'm going to clarify through words denoting number, gender, and so forth. Well, that so forth includes the name. So when I use words denoting number, gender, and so forth in reference to the name, sorry, I don't have one of those either. Persons have names. This guy looked at me and said, "Well, everybody has a name." No. This body right here, before I was even formed in the belly, I was known. I was known long before any name was cast. I was known long before any name was cast as being sanctified and ordained as a prophet. Before I was even formed in the belly, before I had a body. This is a simple fact. This is why I say the right to remain silent. The fuck, excuse my language, I ain't going to remain silent. I'm going to speak, and I'm going to speak the truth. You try to hold that against me in a court of law. Try to prove my incompetence. I'll prove the incompetence of the words that you're using trying to denote number, gender, and so forth. I'll prove by the number on your citation that you don't even know what the hell you're doing. That's not an OMB control number. It's not current. It's not valid. That proves it's under your own station, under your own capacity. You are operating in your private capacity in regards to liability. And when I pull that bond, you will never be bondable again. No one will hire you as an officer of any court for any position. You will be resolving to have to go to work to McDonald's, buddy. You will not be making that 75 grand a year. You will not be making that 125 grand a year. You will not be making that 175,000 ridiculous dollars a year for making contracts which you are incompetent to do so. The source. See Rule 12b-2. Rule 12 of the Federal Rules of Civil Procedure in regards to contracts, folks, talks about identification. Talks about the jurisdictions. 12b-2 talks for lack of personal jurisdiction. If they can't have custody of the person, then how do they have personal jurisdiction? The primary element in order to bring any case. All they can do is write something down on a piece of paper, and if they're not competent to write it in the correct style, then that's on them. So when I tell somebody, I've been called Keith all my life. I don't have a name, but I've been called Keith all my life. And Mom and Dad, when they got mad at me, they used to call me Keith Orland. Now I hail from the family Little. If that incompetent sucker wants to write it down as first, middle, and last name, as if though I gave him a first, middle, and last name in custody, that would be his incompetence. Because I never did so. I never used words denoting a name. In fact, I clarified that there was no name. And I will clarify today that that legal fiction through adoption is an assumption of the facts of the court. Because again, I profess that I was born. Long before I was called Keith Orland Little, I was called Keith Orland Conrady. Don't know what to tell you in regards to words denoting numbers, gender, and so forth. But it certainly I didn't identify myself. And this is proof on and for the record that it only identifies a legal fiction. And nobody can identify myself. Nobody. Not even you today. You cannot possibly identify me without me acknowledging it first. If you go writing down to somebody else that my friend Keith Orland Little told you this, this, and this, that would be a lie. That would be a lie. That would be a lie. I assure you. Second one, practice of law by the justices and judges. Remember again, people, they're getting paid emoluments. They can't possibly practice law. They're practicing commerce. Pure and simple. Nothing more and nothing less. They're practicing to perfect their title. I don't need a title for perfection. I can't be perfect. I have to accept that part to realize my power of destroying their perfect titles. That is Title 28, Section 454, Practice of Law by the Justices and Judges. Every last one of them gets paid a paycheck. It's an emolument. They're getting paid because they're in a contract and they want me involved. That means I'm involved in that contract as well. Then I better use certain words denoting the numbers, gender, and so forth. And the words that I use aren't the same as theirs. So they can't possibly come to a meeting of the minds to form a contract. Pure and simple. It's as simple as it gets. So when they try to railroad you into the courts, Practice of law by the justice of the judges. Title 28, Section 454. Title 42, Section 1983. This is the Social Security Act. This is why we bring in Section 5. Because it's all Social Security Administration. Okay? This is civil action for the vacation of the rights. This is by using that contract that we're supposed to be beneficiaries of against us. They're already using everything we've said and done against us in these supposed courts of law, which again is bullshit. Title 18 of the United States Code, Section 241 and 242, for the lack of rights, violation of rights, conspiracy against the rights. Title 18, Section 1621, perjury of the oath. Again, they're taking an oath under God for commercial emoluments. Title 18, Section 1201, kidnapping. That's 20 years or $75,000 or both. Title 42, Section 1986, neglect of the correction of the wrong, and 1985 falls right in there for the vacation of the rights or privileges. Title 42, 1986 is also in regards to the knowledge of the law. They're supposed to, again, these are contracts. These people know what they're doing on the bench. They know they're contracting, and that is the violation. They're violating your rights by bringing you as a private man into a public venue, and then you have to express your private right to try to get out of that venue while they're trying to form a contract because you don't know the words that you're using in regards to their denoting numbers, numbers, gender, and so forth. And that's what they're using against you. I have no need for numbers. I have no need for gender. I have no need for the so forth. I have need for my neighbors, love, my Mother Earth, and my Father in heaven. I need nothing more. I want nothing more. I desire nothing more. In that, I have everything I need. And you can't prove otherwise. Because everything above and beyond that, it is an assertion of a need that is only a desire. Pure and simple. Because I still live. Despite all of this society's requirements, I still live. And I will continue to live tomorrow if this place gets blasted off the earth. Title 18, Section 2381, treason. Title 18, Section 2382, misprision of treason. Title 46, Section 190 through 194 talks about bill of lading. And every instrument they issue is a bill of lading. It is a start of a new contract. The dog leash guy wants to come around from the dog pound and give you a citation. He too is acting in a public trustee position while getting paid emoluments through a private organization and is issuing a bill of lading. He will not show up in court. And neither will I. However, if it is like I've explained, a dog at large, dog causing injury, I will go to the actual victim. And I will not tamper with him. I will ask him about his true testimony. And then standing there and watching his true testimony. And watching his kids cry because his dog got bit by my dog. I will make my agreement in equity with him and his family and no one else. And that's how I have my standing in nature. I go to the source. I don't need to go to some court to recompense the victim in a case where there was truly a victim. And I've done... granted, my dog has attacked more than once, and so I've done this more than once. I've gone to the victim and paid their vet bill and gave them extra more than once. This is how your actions speak louder than words. And again, like I stated in one of my earlier videos, you have to pay attention to your own actions as well as theirs. When you want to sit there and complain about their actions, you have to realize your own actions and the wrong in them. Yes, it's called integrity. Thank you for that action. It is called integrity. Because to this day, one of the main people that caused me problems in with the issue of where I used to live and tried to set my roots, I was consequently assaulted by the same people because they have zero integrity. I went and paid. I didn't need to go to court and pay for this dog's damage. I went to these people. I shook this man's hand, and I stood there and cried and apologized. And this is the man that came back and assaulted me because he had zero integrity, because he was full of fear. Because even though I showed my integrity, and my recompense and my egregious, my own grieving for the acts that my irresponsibility caused. In his fear of my dog attacking his dog again, he proceeded to cause further and further issues to get me out of the neighborhood. It's very sad that people would do that. But despite that, I didn't take that out against the next victim of my dog and my irresponsibility. I still stood up in the same integrity and went to that man and his family and shook his man again, crying, because I saw how bad I would feel very bad if another dog attacked my dog, no matter what reason, because I feel for my dog and the pain he's going through. I care about the rest of life. It's not just you, my brothers and sisters, that I love. I care about and love all of life. This is my true contract. This is where my true muscular contracts generate towards. This is what my true muscular contracts denote. Not through words, gender, and so forth. I care not. Through the legal process, naturalization in regards to the United States is when a foreign national can obtain a U.S. citizenship. That statement alone, through the legal process, and this is something I will post when I get done. I will pull up this link. It's uscis.gov help center / help center / article / what is the difference between a certificate of citizenship and a certificate of nationalization or naturalization. And in this, it tells us that the foreign national is the one that applies for naturalization. And when it comes to foreign nationals, this is what the United States is doing with the birth certificate and certificate of life. A certificate of live birth is conferring a naturalization through nationalization. Still, it's just the conference of a corporate entity, a legal entity. That's all it is. So again, their name is not applicable to myself. I do not have a name. Period. I am a foreign national. It matters not what you wish to call me. If I decide at any time that I want to go by Tom Sawyer, I'll go by Tom Sawyer. If I want to change and decide I want to play the character of Huckleberry Finn, I'll be damned if I didn't all of a sudden decide to change and decide I want to play Grandma Merrick. How's that for gender? Huh? Yeah. Oh, yeah. The next one, Yeah. In accordance to all their emoluments, Title 15 of the U.S. Code 1692E, false or misleading representations. Because again, like I said earlier, if they're trying to pull you into their public courts, that proves it's a contractual situation and not a private criminal process. Because anything in the public venue is a matter of civility, and it is therefore a matter of contract, and therefore it is a matter of whether the words denoting number, gender, and so forth are actually valid definitions. Pure and simple. And they're not. That's false and misleading representation, because they're using their words denoting numbers, gender, and so forth without being able to enact them until you step up to do so. They can't be enacted unless you agree to them. Again, signature. I'm sorry. You look at all these sports guys giving these signatures, and they don't proclaim them as signatures. They claim them as autographs. Why? Because they're giving them in a different capacity. They're giving away think about this. They're giving away a basketball, and they're going to put an autograph on it, and somebody else gets to hold it for a commercial value. What's that have to do with signature? It doesn't have anything to do with the guy's autograph. It has to do with the guy that's holding it and wants to sell it to somebody else, or hold on to it until it has enough special value that he can then turn around and transfer that value to somebody else. That's the entirety of the agreement, is the specification of the value. And if you don't put the word down as the value, then you're getting screwed. Pure and simple. So think about this stuff, people, and remember that everything you say can and will be used against you in a court of law unless you know what the definitions are. If they can't enact those definitions, like I said, the person, the individual, all that stuff, the officer, if they can't enact them, then there's no enforcement. I've got 11 citations down there, 7 to 9 years old, that they couldn't enact because I didn't act upon them myself. I signed with a reservation under their commercial situation, UCC 1-308, reserving my rights. And I'll be damned if they're going to try to get me to walk into that court and profess the UCC. They're going to find out that the words denoting numbers, gender, and so forth aren't valid. Even in the UCC. Even in the UCC. It was authorized by the United States that I am not liable. Under the UCC 3-402B subsection 1, the authorized representative giving an unambiguous authorized signature on the instrument is not liable for the person named in the instrument. On and in, authorized representative, and the UCC being incorporated through statutes under contract through the Federal Acquisitions Regulations says that I'm not liable for their acquisitions. Pure and simple. No matter whether it's a signature or an autograph. Why am I not liable? Because I am in fact the beneficiary and you are in fact the trustee. And the federal government is in fact the one that granted you the capacity to be able to use that value system. And it doesn't apply to me if I don't want it to apply to me. Now, if I want to take benefit, then I have to take benefit by making sure that the account is settled accordingly and that all obligations are discharged. Now, if you're not going to do that in that proper capacity according to your private emoluments through the judicial system, I'm going to step right up over the legislative system, denoting words, numbers, using words denoting numbers, gender, and so forth, and step into the executive capacity and define them for myself. How's that for you? I'm going to make you the mud on the bottom of my shoe. This is how powerful it is once you learn this information, people. So understand how to assert not only your knowledge, but your integrity. Like Asha Marie, I appreciate that comment because that's what it comes down to is integrity. If you don't have the integrity to stand your square despite everything they say without being able to tear down knowing that you have to tear down every word they use because they can't properly enact them unless you recognize them in the same capacity that they're using them in. So when that officer pulls you over and asks for a driver license, and he doesn't even know what driver means or license means, then you have to let him know that anything he says can and will be used against him in a court of law. You have to give him that notice of legal responsibility. If you give him that notice of legal responsibility, anything he says, he can remain silent, but he's going to sit there and profess his trustee position. And that's what you have to recognize him in. He cannot benefit from his emoluments. He must assert that he knows the law and if in that trustee position. And if in that trustee position he's making a determination of the law without the legal, without the license to do so, then he can't prove his concept of license, let alone his concept of driver. Because in fact, alongside the road, he is in fact using his own discretion. Ask him. That's part of their training, to use their own discretion. That's their primary thing, is to use their own discretion. They make these people believe that they are intelligent and that their discretion is important. Well, yeah, it's important, because if they use their own discretion and don't know what that discretion is and they're getting paid for it, they're simply going to do it because it's their job to do so and let somebody else figure it out. They think that they're putting the liability on the prosecutor. They're placing part of the liability on the prosecutor, and they're placing part of the liability on the clerk, and they're placing part of the liability on the Secretary of State. They're placing part of the liability on a lot of them, but the main liability resides on them because they're the one giving the signature, not the prosecutor, not the clerk, not the president, not the Secretary of State, but them. And they're doing so in their incompetence. They don't even know what the word citation means. Ask them. Ask them if they know, if they're familiar with the words denoting number, gender, and so forth used within the code, that when they use traffic, it means commerce, transportation, and trade all in the same thing. It means the same thing. And in so defining that, it also means trade or business, which means the performance of the functions of a public office, of which they are the officer of, and their performance is an obligation of which they are getting paid to do so. No, I'm just getting paid to do a job. Well, yeah, I'm performing the functions of public office. So you are incorporating in a trade or business for federal tax purposes. Well, no, I'm doing it for the state statute. Well, isn't the state statute written for federal tax purposes? Well, no, it's a traffic citation. Well, let's look at the transportation code, wherein the motor vehicle operator's lease is defined. Or excuse me, it's not defined in the transportation code, is it? It's defined in the federal tax code. Oh, wait a minute. Does the officer have a separate statement signed separately from any other license or lease agreement or registration or application or form that he has filed, stating under penalty of perjury his use of that vehicle, at least 50% of its use for trade or business? Does that officer, in fact, have a motor vehicle operator's lease? Ask him. Do you have a driver license? Yeah. If he says yeah, ask him. Ask him if he filled out a separate statement with a separate signature, wet ink, stating, oh, and it's handwritten. It does say Let me look it up. Make sure they haven't changed it. So make sure they haven't changed this, because I'll show you guys right where it's located. It's one of my favorite sections of the code. H. Section H of Title 26 of the U.S. Code, Section 7701, Tax Code. Motor vehicle operator leases. In general, such agreement shall be treated as a lease. The lessee shall not be treated as the owner. Qualified motor vehicle operating agreement defined. Okay, now they've changed this. It used to be qualified motor vehicle operator lease. Now it's qualified motor vehicle operating agreement defined, but up here it says such agreement shall be treated as a lease. Okay, so it's still qualified. In general, the term qualified motor vehicle operating agreement means any agreement with respect to a motor vehicle which meets the requirements of subparagraphs B, C, and D. And D. D is a very important one. Minimum liability. C talks about the certification by lessee. Notice of tax ownership. This an agreement made with meets the requirements of this subparagraph if such agreement contains a separate written, not typed, not printed, not copied, not reproduced, not duplicate, but separate written statement separately signed by the lessee. It is not the license. It is not the lease agreement. It is a written separate statement, a separate written statement, separately signed by the lessee, under which the lessee certifies under penalty of perjury that it intends that more than 50% of the use of the property subject to the agreement, the motor vehicle, is to be in trade or business of the lessee. Trade or business being includes the performance, the obligation. Performance is the obligation of the functions of a public office. And when we talk about the functions of a public office and the obligation, it is Title 18 of the United States Code, wherein it talks about bonds or obligations or other securities of the United States. Again, where we speak of the first three words says includes all bonds. Includes all bonds. That bond is in words denoting number, gender, and so forth, wherein the officer includes any person authorized by law to perform the duties of the office. The functions of public office. Are they or not the public servant performing the functions of a public office, known as the performance of the functions of the office of trade or business, denoted through the government public office or publications office, government accountability office, and U.S. Department of State. For again, Title 26A, 26, trade or business. Again, we're in the exact same code, people. Title 26 of the U.S. Code, 7701, definitions. These people have to have an operating lease. That operating lease has to have a separate written statement, separately signed, acknowledging under penalty of perjury their office and the obligation of the performance of the office. They are admitting they're an officer. Don't know what to tell them. So think about this, people. Think about it seriously. The notice of legal responsibility is the first element of notice, or first element of due process of law. They're not going to give you legal notice. So until somebody steps up and gives legal notice of the absolute elements of due process of law, then they will continue to operate in commerce, and they will continue to operate against you using your words, denoting the numbers, gender, and so forth against you. Clarify yourself and know how to act so that they cannot enact their contracts against you. Pure and simple. Anyway, just like always, I'm going to post my other forum links and everything along with that PayPal link. I do ask people to hit that PayPal link and send me some love. This is the thing that I depend upon in regards to those Federal Reserve notes. I do this 24/7. I put this information out there. I commit good acts in His good name. I do His good works as much as possible. This deletes my ability from having a job and just doing my job. I can't do that anymore. I can't subscribe myself to that. So please hit that love. Send me some love. Know I'm your neighbor, and I honor and cherish you all. And in the meantime, even if you can't do that, show me your love by sharing the information that I post. Share the videos that I post. Share the links to my forum so that other people can see all this information and all the videos, and further that progress for all of us. And remember, if it wasn't for you guys, I would not be doing this. I love you all. God bless, and have a great day.